Hello, this is Debbie Reynolds with the Data Diva Talks podcast, where we discuss data privacy issues with industry leaders around the world with insights that businesses need to know now. I am so delighted to have a very stellar professional and a dear friend of mine, Jeff Salling, on this show. Jeff, please say hello to my audience.
Hi, audience. We're very honored to be here with Debbie, or as she's known in my house, Aunt Debbie.
Exactly. I was so excited. You just don't know. Like last night, it was like Christmas Eve. I couldn't wait to talk to you today, especially because of the pandemic. You know, you and I, we've touched base obviously over the months, but we haven't had a chance to talk as much as we typically do. I think over the years, we've probably talked hundreds of hours about data and technology and stuff like that. So it's nice and fun for us to be able to geek out today together on this podcast and talk about all the wacky things that are happening in data and technology and data privacy and what's happening in your world. So, Jeff, you're the global director of eDiscovery for Novartis, correct? Is that the right title?
That's correct. Today, that's what they call me.
You're the head honcho. You and I met in Chicago. Actually, you contacted me many years ago on LinkedIn, and you and I both had in common, we were working in the eDiscovery field, and we both did adjunct professor work. So you were an adjunct at, I want to say Cleveland Marshall. We do a Cleveland Marshall
We
thing
do Cleveland,
together.
yeah. I'm John Marshall.
John Marshall Law School.
If it has Marshall in it, they include me. Otherwise, I'm not invited.
Exactly. So actually, you asked me to guest speak in your class a couple of times. And actually, probably some of the first video recordings I ever did of any educational things I had done with you.
Those are still going strong as of this summer.
Oh, good.
The students still know about Debbie Reynolds is still there.
Well, glad that stuff that we were talking about is evergreen in that way. I don't know. Mm-hmm. Maybe that's a sad commentary. I don't know. Things definitely don't change that much. But I think you have a very unique point of view because, of course, you're American, but you lived over in Europe. Your job with Novartis, especially, I think, pharmaceutical companies, you all touch almost any regulation on earth that I can think of. So it's, you have issues with customers, you're working with people in different countries, all this, all the things that are swirling around with the changes and regulations around the world definitely impact you. And I think people sort of don't understand that a lot of people like us who have been dealing with eDiscovery and multinational corporations, we've been dealing with privacy for decades. So it's just been a part of our work. And then once the fine thing with the GDPR came out, then all of a sudden people are like, oh my God, privacy is a thing. So we're like, what? It was just like a line item on your job description before. And now it's like a huge, individual thing. What are your thoughts about that?
Yeah, well, I remember when I got the offer to go to Switzerland, obviously you being one of the people I talked to, and what we talked about was where Switzerland isn't part of the EU. Obviously, we're surrounded by the EU, and that to move there right before GDPR went into effect would be such a great way to kind of hone those skills around privacy and learn a lot more. We're very lucky that we have a huge data privacy team. So I often have people who know a lot about it that I can go to. Obviously, I also have friends like yourself who, when I have questions and things that I don't know the answer to when it comes to privacy. But even going back to your comments around our discussion being evergreen, I think part of the reason why a discussion you and I could have on data privacy 4 years ago still being relevant today is because we were forward thinkers. We weren't caught off guard. It's amazing how often now, I guess in one regard, I do hear councils talk about privacy, because I think, as you know, even 3 and 4 years ago, we were the ones bringing it up. Like, hey, remember we can't just put those emails on a hard drive and ship it over here. Why not? Like, well, because we're going to violate privacy laws if we do that, or potentially violate privacy laws. On the other end of that spectrum, there's still a lot of conversations that we have with outside counsels. They're like, well, I mean, it's just going to cause a huge problem if we put redactions on those documents. Like, we already know the other side's going to complain, so like, let's just not do it here. Like, all right, if you want to put yourself on the hook for 4% of our global revenue, then maybe we'll make that decision. But even that alone, we wouldn't do it because of the reputational harm. And I think sometimes that aspect gets overlooked, that at least our counsels who are on top of it are, they're the ones saying, well, it's 4%. Like, there's no way you should ever take this risk. It's 4%, so we need to do this. But I think 4% would be relevant, but not as relevant as the reputational harm. We don't want to be that pharma company who's violating data privacy. So that means we spend an awful lot of money to draw little boxes, or today, and in some cases, have computers draw little boxes to make sure that we're compliant.
Yeah. And actually, what I like to say to lawyers, I say, you can't break laws to make laws. So your case, a lot of times people, they're thinking about the issues in their case, and they're thinking about it sort of with blinders on. But if you're trampling on the rights of individuals, you're still, you're going to end up worse off than you were before if you're not following those things. So just opening up people's eyes and having that conversation. And like you said, we've had these conversations thousands of times over decades about this stuff.
Mm-hmm.
I was talking to a girl the other day about blocking statutes, and I'm like, blocking statutes have been around for decades. It's like, this is so not a new thing. So a lot of the things that people are kind of up in arms about, especially, respecting the rights of individuals, not a new thing.
No, it's not. But it's also, I think that puts us sometimes in a difficult position because we have spoken about it thousands of times. So it's, in a lot of cases, if we didn't have good handbooks and playbooks and documentation, I probably wouldn't ask about it, because for me, I would just take it for granted. Like, well, we have custodians in Germany, in Italy, and in Switzerland. We're not going to just throw that information on a hard drive and ship it back. But I know we'd have counsels who that would be their solution. And yeah. I think you make a very good point of getting outside of the blinders, because I think I see it still in two regards. Big picture wise and small picture. And I think big picture wise, just for the company, like, I can't put the company at risk for my one small matter or even for my one big matter. I have to think about what's good for the enterprise. But I even see it on the matter to say, as you said, like, you're trampling individual rights and fundamental rights in many of these countries. And I see it in a counsel who really can't grapple with, well, in the US, we don't really care. We produce whatever. So let's just do that here. And, that's what you're trained, your schooling. Apparently, most of the matters that you've worked on already didn't have this international component. But when it does, you need to, I guess, take those blinders off and realize that in other places, and one's not better than the other, one's just easier and cheaper than the other.
Right.
But that doesn't make it necessarily better for the people.
Yeah. I want to talk to you a bit about this. I think you may have a good perspective of this, again, because you lived in Europe and you're working with a multinational company that has all these privacy concerns. I hear people sometimes talk about kind of an American view of privacy, not necessarily just in the U.S., just in regards to the U.S. laws. But I don't know, maybe that means like a more of a cowboy attitude about things. I don't know. I wanted to know if you had any thoughts about that, because I hear a lot of my European counterparts mention that at times, and I wanted your perspective on that.
Yeah. We recently were on a call where the distinction was made, and I guess I'd say, having lived abroad, it's, well, you just don't care in the U.S. about privacy. And I was like, well, we care less, but we do care, and there's specific things you care a lot about. Your social security number, or definitely credit card numbers. But there's some things, and I guess in the U.S. it varies a lot more. And the next U.S. in Switzerland, you can just, even culturally, it's a different atmosphere. It's a much more private atmosphere. And again, it doesn't make it any better or worse. It just makes it different, and making sure that you respect that.
Right.
And then in our role, I guess more importantly, that you understand it.
Right.
Because if you are asking certain questions, if you are, especially even just having discussions, something really simple like a legal hold. I remember the first time I sent a legal hold out to people in Germany, like the questions I got back, like, am I in trouble? Am I being I'm like, no, I was just like, this was my way of letting you know that there's something going on, and your name might just be in an org chart somewhere. Like, you might not. We're just taking our kind of first cut and making sure we get this out timely. We don't always have time to do these in-depth custodian interviews before we can get a holdout. But the reaction I got was like this worry of, I did something wrong, I'm in trouble, I'm being investigated. When realistically, we're probably not even going to collect from that person as the matter progresses. It's just, we're making sure we're doing our due diligence and including the right people. So there's a personal attachment there that we don't regularly see in the U.S.
Yeah, I think, I guess the way I would describe it is, people in Europe feel about privacy like people in the US feel about freedom of speech. I think that's probably about as equivalent as I can get it.
Yeah.
Where I think about the privacy thing in the US is more about people not understanding. So I don't know the last time you read the Constitution, but people think there are magical things in there that aren't in there, and it's not that long. So I highly recommend people read the Constitution and figure out the privacy isn't like in there really.
I think we could make this a 12-hour podcast if we talked about what people think is in the Constitution that is not in the Constitution. But I know that that's not a direction you would want me to go in on this particular conversation. So I'll drink from my Disney Paris mug on that front.
I love it. I love it. I would love to talk about the Privacy Shield invalidation. Now, we've been watching these Schrems cases play out for years. And I was one, before this case came up, probably 3 people in the world I can think of were even talking about it. And I'm like, hey, this is like a huge thing. This is probably going to get invalidated. I'm not sure why it wasn't invalidated before. But was it a surprise to you when the Privacy Shield got invalidated?
No, it wasn't. But I guess it's because of our conversations and saying, like, well, this has to happen next.
Yeah.
And you bring up another good point, because one of the things I remember when I did move to Switzerland, and I'm thinking, like, I got to get my GDPR hat on. We're getting GDPR ready. I've got, I think, 5 months until GDPR hits. And I remember one of the first things I asked one of our litigators to say, what do we need to do? He's like, we've been doing this for a long time. I'm like, but in the US, like, this seems like this, like, well, we've cared about individual rights long before someone told us to and was going to penalize us. So we're all set. Like, yes, there will be things to update and change. There always will be. But as I got there, I realized, oh man, they're ready.
Oh yeah.
And I felt the same with the invalidation of the Privacy Shield. I thought, like, we're ready for this because we understand it, and we didn't rely on some of these mechanisms that allowed for data transfers and things like that, because I want to say it just, in some ways, it added to the administrative burden.
Right.
Who am
Yeah.
I sending it to? Do they have this? And then also knowing this will be invalidated at some point, not knowing the timing on what that would have been, but did we want to build a best practice around something we knew would be invalidated? And the answer was no.
Yeah, and actually, so when the safe harbor, that was a shock though. So when the safe harbor got invalidated because they had been in play for what 15 years at that
Mm-hmm.
point, that was shocking. So I don't think anybody thought that Max Schrems' case was gonna have that impact. But when it did, less than half of the people who were part of Safe Harbor signed up for the Privacy Shield. So at least 50% of those people thought, well, let me find some other alternate way. So the people who it was invalidated with this time, they're kind of in a pickle in some regards because the U.S. is requiring those companies to sort of stay compliant with the Privacy Shield, even though it's been invalidated. I guess there's some level of talks happening between the US and the EU about this. But I feel like what happened was because people were shocked about the safe harbor being invalidated and they wanted to put something in place, they sort of hurriedly put together the Privacy Shield framework, which
Mm-hmm.
wasn't that different, in my opinion, from the safe harbor, really. They added a couple of things, but it wasn't significantly different. But I think the reason why they did that was to try to keep the lines of communication open. And remember, this happened in 2016. So as the new administration was coming aboard, they wanted to see how much they would want to um, uh, have more dialogue and communication and understanding between,
Mm-hmm.
the EU and the US. And apparently that did not happen. So I think that they use this Shrimps case as an opportunity to say, hey, we don't like the way that this is going and let me take my ball and go home, basically. Well,
Yeah. I think it was a missed opportunity.
oh, it's a huge missed opportunity.
What it kind of reminded me of is you and I are working, 4:30 hits, and our boss says, "Hey, did you have that privacy shield by 5?" And we're like, "Oh, Debbie, did you do it? You didn't do it either? All right. Well, in 30 minutes, let's just tweak what we had and submit that." And they had the opportunity for some very bright privacy minds that could have put something together. And I don't know, it would have got to the level where it would have been a long-term solution, because I think for that to happen, there would have needed to have been significant changes. But I think we could have withstood, what did we get? 4 years, 3 years, 4 years then?
It wasn't quite 4. It
Okay.
was a couple
I think we
years.
could have got a little bit more.
4, yeah.
And I know the Swiss Privacy Shield was right behind this
Yeah,
Privacy Shield,
exactly.
both ways in
Yeah.
moving on and then also being, turned away now. But it was a big missed opportunity, but it did make it very easy on companies in those few years because they didn't need to make that big of changes. Add
Yeah.
someone that you can contact, a few other small things, and they were able to turn it around. And I think those of us who read it
Right.
and understood it knew this won't last long because you didn't address the concerns. You address, 2 of 52.
Right, exactly. And then too, I think the Cloud Act coming in 2018 is creating also another problem with the Privacy Shield, in that now you're saying the courts have this extraterritorial reach, with U.S. companies in different countries to be able to take data regardless because of surveillance. And as you know, that's the big issue, and it has been. I mean, even when the Privacy Shield was enacted, I'm like, this is like the major issue this is the reason why the Safe Harbor was invalidated. So not addressing that issue with the Privacy Shield, I saw as a problem. But then the Cloud Act, which was supposed to be a way to get companies out of the hot seat, where they're saying, like, look, we'll give you the data, but then you have to work with the country to try to work out these deals. So now, because of that, I think that's going to make any future Privacy Shield 3.0 like even that much more difficult to do.
Yeah, no, I agree. We've had a few matters that we go through the Hague Convention, and those steps. And I think ideally what I hope to see is that we more regularly get into tiered discovery. and I've been a huge proponent of that since I've been in this role, that if we have, for easy math, we'll just say 100 custodians, and 50 are in the EU or in Switzerland, and 50 are in the US, let's start with smaller amounts and let's have real discussions. And I know it's always going to be tricky because we're adversaries, but what we've seen is our sophisticated adversaries, they're on board with it, because they also, why would they want to review a bunch of garbage that comes out, or a lot of redacted documents and things like that? The bigger challenge today, and this is probably the topic I focus on the most in my class, is that discovery and privacy have now taken, in some matters, priority over the merits of the case. Like, you don't get to the merits anymore because, and I won't even say because there's discovery violations, it's because one party has made the appearance of discovery violations, whether they're appropriate or not. One side has argued so vehemently against what the other side's doing or what they're disclosing. And that, I can say, it's a bit frustrating, because those of us who've been doing it for a while, we could do better at making those arguments.
Oh, yeah.
But I feel like it's somewhat against our morals and ethics, that if someone doesn't have a true violation, I wouldn't want to make that argument. I don't think it's appropriate to make that argument. Yet on a regular basis now, we get questioned on some of the most ridiculous things. And again, thinking how forward-thinking we are, we have people who complain about email threading, who complain about deduplication.
Yeah.
I recently had someone tell me that that's the suppression of evidence.
Oh my goodness.
And you kind of pause and you're like, that was a real comment. Okay, we'll continue then. I just waiting for a laugh or the next punchline. And it's amazing, because I think, like, well, actually, we decided this like 10 years ago. Can we at least talk about something that's from the last 5? Like, at least complain about tar. So
Yeah, exactly.
That at least people complained about 5 years ago. And then we have even governments now, which is where I'd say I'm most surprised by some parties when I see the government being substantially more sophisticated than some parties when it comes to ESI protocols, when it comes to privacy.
Yeah.
Saying, like, you just need to educate us sometimes on what you need to take out of a document if it's coming from Switzerland, what Swiss rules are. We'll grab some local Swiss counsel who are excellent to say, here are our requirements. This is what we need. If you don't like this, you can go through the Hague, and that's an avenue that's open. It's going to take longer, or we need to comply with this. And
yeah,
and I always think it's interesting when we get arguments to that, because our opinion is always like, we're paying more to do this. Like, we don't want to do that. We would like to give you more. You want more. We want to give you more, but we can't violate people's rights to do that.
Exactly. I don't know. I feel like some people were like, I didn't learn this in law school. So I'm, my defense is going to be to argue about it instead of really learn. Like, this is totally new and different. It's not something you probably learned in law school. And maybe, especially for cases that have sort of US and other, like, say, US and European data. For me, I've always handled those separately, like a parallel track, but separate workflow and everything, because it gets too complicated. Where in the US, we're used to, the Hoover vacuum coming in and just suck up everything and throw it into a hopper, and then Europe is not accustomed to collecting that much data. So you're going to have less data anyway, in my opinion. And then you need to be more careful with how you handle that. I would love to talk about redactions, your favorite topic, I'm sure. So in the GDPR, when they talk about, creating pseudonyms and then making things anonymous for industries that haven't done any redaction. Okay, so people say, okay, we'll just, make it anonymous or whatever. And maybe they think they're putting a piece of tape on a piece of paper and just sending it over. And we know it's not that magical. I want to talk with you, your feeling about redaction, especially for people, because a lot of people who are listening to this podcast aren't necessarily eDiscovery, but because we're all working on data, we all have these same challenges when we're working with multinational companies. So give me a little flavor of what people can expect and why redaction or creating pseudonyms or creating anonymous documents or it's not as easy as it sounds.
Great point. The first thing I'll say on redactions is know how to do it. You have one of the president's trusted advisors. He produced some documents. I think this is back in 2017 in PDF form with redactions that weren't actually burned into the document. So any of us who saw this, we were able to take the document and see what was underneath it. I believe it was actually the same thing happened in the Wells Fargo case from a few years back where they had the big disclosure of their 10,000 biggest clients' portfolios. You have to know how to do it. You have to work with people who know how to do it. And that's where the tools you're using definitely come into play. If you're drawing the boxes on TIFF images, that process is kind of tried and true. It's been around for a very long time. That's going to work. If you're using some of the native redaction tools, you need the right workflow to make sure when the production happens, you actually produce the redaction on the native document. You don't produce the earlier version pre-redaction that's kept in the background, or the TIFF image that you ended up not redacting because you did the native document, but you already had TIFF the document. So there's things like that that can just be workflow nightmares.
Right.
And then another really important piece for redaction that I think sometimes gets missed, and I know that we recently had a conversation with this, is, well, can't you just ask the custodian to waive their rights? And I said, well, first of all, you can ask, you can seek consent. In some places, there are some jurisdictions that say pretty much from your employer, you can't give a free consent. But if we take that aside and we say that, we'll take consent, you can consent to your privacy rights. So if Debbie and I are living in the EU and we're emailing back and forth, and I can waive my rights, but if we're emailing back and we're sharing pictures of friends and family and we're talking about private things, Debbie's rights are also in my email, and I can't waive her rights. I can't say, she's fine with it too. Whether she is or not, I don't have that power.
Mm-hmm.
So to actually not just go to a custodian, but go to every single person that might have private information in their email account, it's not really feasible.
Right.
Especially on a larger matter. So it's understanding what needs to come out of those documents, what you really want to include, because maybe I'm the person who's the subject of this investigation. So if my information was not redacted, it would be a huge benefit. And Debbie, being a much better behaving employee, a much more wholesome individual, she's not doing anything wrong. So they're not looking to investigate the things that she's saying. That might be, a middle ground. I hope to see the technology here get a lot better. I think it already has. Mm-hmm. This first wave of kind of privacy identification, and mm-hmm. then this next wave of building the redactions around these coordinates or these tools. Mm-hmm. Ideally, at least it gets us, even if it was half the way there, even 25% of the way there.
Yeah.
That would just be a tremendous benefit for us to be able to process, auto-redact out the portion. And always are going to need people when it comes to something this serious. We're likely going to need human eyes on there for a little bit longer anyway.
Right.
But yeah. I'm one of those people that thinks the computers are already beating us at chess, at driving. We're not going to be long before it's going to be able to find privacy information a little bit better than us.
Exactly. So how do you feel, or is it at all, in your opinion, how is COVID-19 impacting privacy in your work or life, or what are your thoughts about that?
I think COVID has potentially impacted privacy quite a bit. Even a recording like this, if my little man comes running into the room, which for some reason this door doesn't latch. So people regularly come running into this room. Now he's in the video. Maybe he's being recorded.
Right.
Do I want my 4-year-old or my 17-year-old to come in? And I actually thought my 17-year-old would come in because she knew I was talking to Aunt Debbie. I think the only reason she's not is because she's laying down for a nap break during lunch, because napping's more important than eating these days.
That's right.
But any other time of the day, she would have skipped school to come say hi for sure. She would run in, have popped in, "Hi, Aunt Debbie! Aunt Debbie, hi! I miss you. I gotta go though because I'm in class right now." Do I want that out there?
Right.
Do I want their images saved now in a database that Zoom holds and potentially that you hold? What can I do about it if I don't like it? And even from a conversational standpoint, I made the joke earlier that Hunter, my 4-year-old, has probably broken attorney-client privilege, over 10 times since we've been home, because I always wear a headset, even though I'm in the office by myself, just because I don't want other people to hear what's going on. And in this household, they don't want to hear what's going on either. Me too, lawyers for, you're going to talk about discovery at dinner again. Could you be more boring, people? But that aspect, and then it's also just material.
Right.
We had a lot of policies in place, not just from a global privacy standpoint, but even a personal standpoint. And us trying to go to digital, I think it's pushed us there a little bit quicker. Whether it's with signatures, whether it's with contract review, document review, outside of the wonderful world of eDiscovery,
Right.
that we're not supposed to be able to print from home.
Right.
You print at work and you keep things at work. And now, this is work, the home office, but
Right.
our machines didn't even allow us to connect to other printers. And now,
Right.
and I guess similarly around USBs, we had deactivated those. So I'd say we've highlighted a lot of efficiencies around discovery and privacy. And I think one thing that we're highlighting around that combination is how we move data, because we've had people who have had to go on site. I think right in March, one of the first collections we needed to do was in Italy.
Mm-hmm.
It's like, no one's there. How do you get this done? Like, why do we have anything that needs to be done on site? Like, that's a dated approach. So how can we move data in a privacy compliant way via the cloud, via just more efficient means? And I'd say that's one big change we've made, is being able to move our data and then understanding where it goes, because that doesn't mean, well, if I can move it now from anywhere, we're just going to ship it all to the US, because that's where, no, it's still going to stay where it needs to stay,
Right.
until those wonderful redactions are put into place.
Exactly.
But that part has been, it's been really interesting. And then I also think that is going to lead to a whole lot more people are going to focus on the technology to bring these tools that we want to place.
Right.
And that's going to allow us probably to minimize it, instead of 3 years, it's going to be a year from now or a year and a half, because people are focusing on innovating so much more.
I agree. So what is your dream? Okay, so if it was the world according to Jeff, and Jeff could decide what needs to happen with privacy, what would your wish be in privacy over the world?
Besides us being neighbors, so you can watch the kids, so I can go out, go on a date for once in my life when I'm allowed to leave the house again, come over for dinner.
Exactly.
My privacy dream, I would say more unification. The U.S. it's starting to scare me.
Yeah.
If we end up having 50 different regimes, privacy, that's a terrifying thought for us to have to look at. Well, Jeff works in New Jersey, but he lives in Pennsylvania, but he's actually in Michigan right now. What wins the day?
Yeah.
And I guess to some extent where we were at in Switzerland, it was true, because as you know, from visiting, we're right on the German-French-Swiss border.
Right.
So we have people in each place, but at least we had a great process in place for that. In the US, we don't yet. So it's unification. I don't know. I feel like a federal privacy law, as much as I read about it's not going to happen, I don't see how it doesn't. But I also think that just might be me selfishly wanting one clear answer, so I don't need 50 answers.
Right.
Or at least it waiting long enough until I retire, so I don't have to be the one that has 50 different answers in the US along with across the globe. And I guess it's the same outside the US as well. I know India, for one, they were transitioning to closer to a GDPR approach. I know
Right.
that got COVID delayed, but
Yeah.
it still seems like that will happen. It's just delayed. That part's important that we get the unification. I think the next step, though, is that we have real conversations about consent.
Yeah.
And one, if we're going to allow people, if we're going to ask people, if we're going to ask companies, because there are, like in Switzerland, there's not just privacy information around the individual, but also for companies.
Right.
There's third-party business secrets, and I know there's something similar within the GDPR. So are we going to start contracting around it? Because we can do that for business secrets if the contract says so. And then for the individuals, are we going to make it easier for them to give consent? Because there are people like myself who, you can take all of my work emails today and produce them to the government. I don't do personal things in my work account,
Right.
to the extent that my wife lets me. Hey, that's the wrong account. Don't email that account. You know, to email the Gmail. Don't send that to work.
Yeah.
But I don't have a problem with it, and I would sign a waiver because my mindset is, why would I want my company to go through and redact my information when that money could be spent making drugs to save people's lives, or making therapies, or making genetic benefits, genetic therapies to save people's lives? I don't want $1 going to redact out anything I have in an email, because I don't have anything personal or private in my email, because it's my work account and I'm a grown up.
Yeah.
So I don't put things in that account.
Absolutely. Yeah. Cowboy up and separate your personal and your work stuff,
Yep.
folks.
The two phones are there for a reason.
Have my two phones. Yep.
Yep. And even if my company didn't pay for the one, especially with how cheap phones are today, not the phone itself, that's a bit of brutal, but the plans themselves, 40, 50 bucks a month, I'm going to have a work phone forever. And if anyone wants that phone as well, I know that's another kind of hot topic from a privacy perspective, is mobile devices.
Yeah.
If you can even ask for it in some certain jurisdictions, good luck. You're never going to get the phone.
Right.
You can have my phone, my work phone. Personal phone's not going anywhere. But my work phone, same thing. You could take it today. There is not a picture. There's not a text. There's nothing in there that I would care if it got disclosed, because I separate the two, because I do this for a living.
Yeah, yeah. Fantastic. Well, we're coming to the end of our time, but before we end, I wanted to throw in a personal note, and you have to remind me of this. So, a couple years ago, you and I were supposed to speak at a conference in London, and it got moved around, and we couldn't do it. And then you invited me to Switzerland to visit you and the fam, and we had a blast. But you took me up to a castle in France, and I have to thank you for that, because Debbie wouldn't have done that on her own. And you made me, I was not going to go all the way up to the top. And you're like, come on, Debbie, go up here. And I was like, I finally got up there. So I'm happy that I actually did that. So I have to thank you for that, because that was a fantastic experience.
Absolutely. I still have those pictures. Those are still probably my favorite view that I had while living there, to drive over to France, be able to overlook. I think we could probably see to Germany, but definitely France and Switzerland. That was a very, very cool experience, and it was really fun for you, me, and Francie my daughter,
Yeah.
to go to France and do something like that. That was just such a fun experience. We were so happy that you came and joined us, spent that time. It was disappointment that the other two were traveling to the U.S. while you were visiting, but
Yeah,
that made it fun because similar to what we found ourselves in now, unless you're a motivated person, you sometimes can get stagnant. So like we
absolutely.
travel on the weekends and things, but sometimes we just wouldn't do anything for a while. So to have you come and be like, well, Debbie's here, so we got to do something. Let's get out of the house. Let's try a new restaurant. Let's go to France. Let's do these things. It was a really unique experience and really fun to be able to do with such a good friend.
Yeah, that was fun. And then I think we went to a Chinese restaurant with German menus. So that was nice. The food was great though.
I have a goal to have Chinese food in as many different countries as possible, and I'm doing pretty well so far. I'm doing
You
well.
really can't go wrong with Chinese food, like no matter where you go. So if you don't, I'm not sure what to eat, find a Chinese
Yep,
restaurant.
it's gonna be delicious. There's no doubt about it.
Well, thank you so much. This is such a thrill to have this conversation with you. And of course, I'm sure we'll have other conversations as we always do.
Well, it was an honor. I was very excited to get this ask from you. I think you're doing an absolutely fantastic job. I'll make sure that in this house you're still Aunt Debbie, even though I feel like the Data Diva is going to be a more popular name for you across the industry. At most, we'll do Aunt Data Diva, but we'll see where the kids end up.
Oh, that's hilarious. Hilarious. Well, thank you again. And thank you so much for being on the Data Diva Talks Privacy podcast.
An absolute privilege.
So have a good day, and I'll talk to you soon.